Hello, everyone, and welcome back to the latest episode in our series looking at the criminal litigation system in England and Wales. And we're currently on chapter 8 of the series, which is towards the end on sentencing. There's only 2 more episodes left in this mini-series, and that will be chapter 9, appeals, and chapter 10, we'll have a brief look at the youth court system. Just a reminder, it's primarily for bar course students hoping to get a bit of an insight into what's coming up on their course, just a general overview, but also making it an easy, digestible format for the general audience to follow. And again, we're looking at Blackstones syllabus 2025, and that's subject to change. Thank you everyone for subscribing. Hopefully you do enjoy the content and it is informative. If you haven't subscribed or if you haven't watched the previous videos, do recommend you go back. We've followed the course of a criminal case all the way from charge and arrest up to sentencing now. So today we're looking at what happens after conviction, and that's sentencing. It's the moment where the law weighs justice, mercy, and deterrence. Sentencing isn't just about punishment, it's about protecting the public, rehabilitating offenders, and repairing harm done. Every decision follows the Sentencing Act 2020 and the Sentencing Council guidelines, ensuring fairness and consistency. What I will do is in a future video, we'll look at some most common crimes, and we'll look at the sentencing guidelines for those, and we'll work through those just as an example. But modern sentencing law sits within a single framework, and that's the Sentencing Act 2020. It consolidates decades of law into one code, setting out who may be sentenced, what powers exist, and how decisions are reached. Judges and magistrates must follow the Sentencing Council guidelines, unless that would be unjust. They assess seriousness, apply the guideline range, adjust for mitigation and aggravation, and record their reasons. Transparency builds confidence that justice isn't arbitrary, it's principled and structured. Under Section 57(2) of the Sentencing Act 2020, there are 5 statutory purposes. There's not just to punish offenders, it's also to reduce crime through deterrence, to reform and rehabilitate, to protect the public, and to make reparation to victims. Every sentence aims to achieve some or all of these purposes, never revenge but lawful balance. The judge weighs these objectives according to the facts of the case and the offender's personal circumstances. So before selecting a sentence, the court must assess seriousness under Section 63. And seriousness is driven by culpability and harm. And we'll have a look at this on the future videos when we look at an example of the sentencing guidelines. How blameworthy was the offender and what damage was done or risked? The Sentencing Council uses a category matrix. So higher culpability and greater harm mean a higher category. And that assessment anchors the entire process because punishment must fit both the crime and the criminal. So depending on the category, there are certain sentences that are recommended based on the outcome. Once seriousness is set, the judge turns to aggravating and mitigating factors. Aggravating factors raise the sentence. Things like previous convictions, use of a weapon, targeting a vulnerable victim, or acting as part of a group, just to name a few. Mitigating factors pull the sentence down. So things like genuine remorse, being a youth, mental health issues, cooperation, or even efforts to compensate the victim. Under Criminal Procedure Rule 28.3, reasons must be explained in open court. This balance ensures the sentencing reflects both conduct and character. So what about if you hold your hands up at an early stage. So the 2017 guideline gives clear credit for early guilty pleas. A plea at the first opportunity can reduce the sentence by 1/3. If entered later, for example, after the trial begins, credit reduces or may even vanish entirely really quickly. The logic is simple. An early plea saves time, spares victims coming to court to give evidence, and shows acceptance of responsibility. It shows insight and sometimes remorse. Judges must state publicly how that credit has been applied. Before passing sentence, the court may request a pre-sentence report from the probation service. I think we briefly looked at this on the last episode 7 at the end of the criminal trial. The sentence doesn't always follow directly the verdict, and it can be sent to the probation service for a pre-sentence report. The report outlines background, risk, and prospects for rehabilitation, and defense counsel then delivers mitigation, highlighting personal circumstances, things like employment, caring duties, health, remorse, and this is all in an attempt to bring down the sentence before the judge. Together, these materials guide the court towards a proportionate and humane outcome. And for those who are on the bar course or even late training in the LLB or PGDL, you can actually join mooting clubs or societies, and one of the most common moots or mock court type of hearings you can do is something called a plea and mitigation. And this is where you act on behalf of the defence to expand on either a pre-sentence report or analyse the sentencing guidelines and try and bring down the potential sentence for a defendant. And the top marks are given to those who potentially bring it down below the custody threshold or get as light a sentence as possible for the defendant. One of these light sentences could be a community order. So not every offence needs custody. If punishment is required but prison isn't justified, the court may impose a community order under Section 200. It can include unpaid work, curfew, exclusion, treatment, or supervision. And the order is tailored to the offender's risk and needs, aiming for accountability through reform. It's justice carried out in the community, not behind bars. There's a lot of debate about people actually becoming worse off by going to prison and mixing with other criminals and coming out and re-offending. So what's the best way to A, give back to the community, and B, protect those that the convict, the defendant has, whether they have caring responsibilities or have family? How can you safeguard those relationships and not send the rest of their life into a spiral due to going to prison? So custody is the last resort. Under Section 230, no one should be imprisoned unless the offence is so serious that only custody is justified. The judge must explain why the custody threshold is crossed and ensure the term is proportionate. Credit is given for time spent on remand, and parole eligibility is clarified. Even in prison, the goals of rehabilitation and protection continue. So you can actually do work within prison, do courses as well that are accepted by certain employers on the outside. And I think we touched upon this on one of the YouTube shorts, that the prisons are actually full or nearly full at the moment. So, and also there's a backlog in the Crown Court cases. So potentially, if we're currently in 2025, someone could be listed for their trial in 2027 or even 2028. And if they're remanded in custody, they could be serving a considerable length of time in custody before their trial. So that remand goes towards the final, counts as some of the custody limits when the sentence finally comes around. Sometimes custody is justified, but immediate imprisonment isn't necessary. So if the crime was severe or serious, but it probably doesn't warrant them going to prison. And under Section 231, the court can suspend sentences for up to 2 years. The offender remains in the community under strict conditions. Certain things like unpaid work, curfew, rehabilitation can take place. But if those conditions are breached or they do reoffend, the sentence is then activated. Suspension blends deterrence with a genuine risk to reform. Just to be clear, if the sentence is activated, they will be going to prison then. When the defendant is under 18, the focus shifts entirely. So youth sentencing prioritizes welfare and rehabilitation over punishment. We need to get to these offenders early and make sure that they don't go into a life of crime for the foreseeable future. So courts consider age, maturity, and vulnerability. Options are quite varied, and they can include things like referral orders for first-time guilty pleas, youth rehabilitation orders, and for serious offenders, detention and training orders. But custody for children is always a last resort, echoing Article 37 of the UN Convention on the Rights of the Child. This can be quite detailed, so for those who are studying this element of the syllabus, I would recommend going to Blackstones and reading up a bit about the various options available for youth offenders. But also, sentences can include ancillary orders to repair harm or protect others. These might be compensation orders, forfeiture, disqualification, or even costs and surcharges. And this is particularly relevant where the crime has impacted another individual or organisation financially. And they sit alongside the main penalty, ensuring crime never pays. So for instance, if someone's got away with fraud and they've accumulated like over £1 million in their criminal empire, if they're just going to prison for a number of years and they've kept that money, then sometimes you would look at that and think crime pays, I'll just do the time. But these orders are in conjunction with that, just to deter the benefits of crime and to make it clear that crime doesn't pay. So what if you've been convicted of several offences? So often you're tried for all of the offences and you're sentenced separately within the same hearing for all of the offences. And on the syllabus you will look at indictments. We haven't really covered that in detail here, so I would recommend looking at that. But where an offence carries multiple charges or where there's multiple offences, unrelated offences, that will all be taken into consideration for the indictment. But where several offences are sentenced together, the court applies something called the totality principle. So linked conduct usually attracts concurrent sentences. The separate incidents often run consecutively. Separate incidents will run consecutively, whereas linked conduct attracts concurrent sentences. So it makes sense. So if it's all within the same crime, it'll be all amalgamated and run concurrently. However, if it's separate incidents, it's two separate crimes really you're looking at, so it'll be consecutive sentences. So you'll be sentenced for each one. The judge ensures that the overall sentence, though, is just and proportionate, neither excessive nor artificially low. And the totality guideline, originated in 2012, prevents double punishment and maintains fairness across multiple counts. And that leads on to appeals. So what if you're not happy with the sentence? So even after sentencing, the law provides oversight. A defendant may appeal the sentence if it is thought to be manifestly excessive. And likewise, the prosecution, through the Attorney General, may refer cases that are unduly lenient. And appeals are heard by the Court of Appeal Criminal Division, which can reduce, quash, or uphold the sentence. And this process protects consistency and public confidence in justice. Okay, so that's sentencing, just a brief overview. And that's where the moment where justice, rehabilitation, and accountability meet. And just a reminder, this is only really a snapshot. For those of you studying the course, it is a fairly detailed part of the course. I would recommend you referring to your texts and Blackstones Criminal Practice to look at the greater detail. But hopefully that was a good insight. If you found it useful, drop any questions or thoughts in the comment below. I do try to read all of the comments and answer any questions. Don't forget to subscribe for the next episode, and that will be the final stage of the process. It'll be Chapter 9, Appeals and Review. Chapter 10, just a reminder, we'll look solely at youth courts and youth sentencing. So that's a separate standalone chapter. And then we'll make some series of videos looking at some of the more detailed areas of the law, so things like hearsay and identification and things like that. But yeah, thank you for watching. Hope to see you on the next episode. Please do subscribe if possible. And it's goodbye for now. Take care.